Hello everyone, I'm Dr. Shilpi Sarna and today I'm going to discuss a topic which is related with the Indian Contract Act 1872. Today I'm taking the introductory part of the Contract Act 1872. Contract. Every day we involved in various activity where you involved into a various kind of transactions. And we never know the kind of transactions that we are taking actually they are in the meaning of contract. Only the thing that we need to identify whether any transactions creating a legal relations or not. If any transactions creating a legal relations, it means that you are a part of contract. The Indian Contract Act 1872 came into existence of 1st of September 1872, extend to the whole of India except the state of Jammu and Kashmir. Very important because in today's business world, everybody required to deal in the transactions for the same. So being as a management student, you should know that what important rules and regulations that you required while you are dealing into a particular kind of business. Now the important thing is that what is contract? We need to understand, because whenever we are into any transaction, we should understand that whether we are doing any contract or not. So most importantly, that we said that the contract is defined as an agreement which is enforceable by law. So what is agreement and why we are saying that it is enforceable by law? Because every contract that start with an agreement, the agreement which is been between two parties, the one party make an offer, the other party accept that same offer, and this offer and acceptance should be enforced by law. As I told you earlier, that every transaction we cannot deal in terms of a legal relationship or creating a legal relationship. So every agreement, it should be that enforceable by law and should create a legal obligation between both the parties. And most of the time we also said that every contract is an agreement, but every agreement is not a contract. Why it is so? Because there are certain obligations, certain important rules and regulations that every party, both the parties should fulfilled by their own. So if we can see in the slide, there is one agreement. The second is the legal obligation. When they both come together, then only it makes into a contract. Now, as I'm talking about the important obligation where both the parties, they are bound to complete, bound to fulfill, what all are those? Now, these are essential elements of valid contract. We have to fulfill, or we have to see that there should be an offer and acceptance. We have to see there is an intention to create legal relationship. The capacities of the parties are very important. Free consent of the parties should be there. The consideration definitely deal with both the parties. Lawful or the legal object. The certainty of the meaning, the possibility of the performance, not expressly declared to be void, and it should be compliance with the legal formalities. Now I'll start with the first one. Now what is offer and acceptance? So I told you earlier that both the party, those who are coming into an agreement, the agreement first start with offer and acceptance. It means the one party need to generate an offer and another party should accept the same kind of offer. And then only you can be into a relationship of a agreement. So once the offer and acceptance has been made, your offer and acceptance should be create or should be with the intention to create the legal relationship. As we are discussing into our second point, that there should be a legal relationship bounded by both the party. We cannot say, suppose if we are accepting somebody's dinner invitation, it is not the legal relationship creating by or between both the party. So the legal relationship should be bound between both the parties. Now the third one is the capacity of the contract. Under law, it is very important that the party should be capable enough to entering into a contract. Because if you are not capable to entering into a contract, you should not, intend or create a legal or the valid contract with another one. So as per the Indian Contract Act 1872, there are three conditions has to be satisfied while we are talking about the capacity of the contract. The first is that you should be major. You should be sound mind to understand each and everything, and you should not be disqualified by any other law. So if you are having all these kind of, the formalities, then only you can declare to be as a capacity or the capable to entering into a contract. Now the next one is the free consent. Now what is free consent meaning is? Free consent meaning is both the party consent should be free. And we can also say that, the same thing into a same sense. So whatever I am, describing you, whatever I am telling you in terms of my offer, if it is same for me, then definitely it would be same for another party. For example, while selling any kind of a product, if I'm putting all the specification, then the other party should understand, and it should be same for the other party one as well. There should not be any kind of confusion. If there is any concern which has been taken by coercion, which has been taken by undue influence, which has been taken by mistake, fraud or misrepresentation, then the consent is not free. Next, that we should consider about the consideration. Now here the consideration meaning under the contract called money. The money should be adequately exchanged between both the parties. So whenever you are, entering into a contract, there should be a specific money transaction, and most importantly, the adequate money transaction should be done between both the parties. Next is the lawful object. If we are talking about law, if we are entering into a contract, then no illegal object would be entertained between both the parties. If you are making a contract for selling an arms, then it is not a lawful object. So whatever transaction, whatever business that you are looking for, it has to be permitted by your law. Then the next is the certainty of the meanings. Now, what is the meaning of the certainty of the meaning under the contract? Certainty means the transaction should be certain. It should not be based on any future kind of a thing, although there are certain kind of exemption, all that, so we will discuss things into a later. But most importantly, that whenever you are discussing about the thing and the transaction of the business should be certain enough between both the parties. Next, the possibility of the performance. Both the parties should be possibly perform their performance. Now, what is the difference between the capacity of the party and the possibility? Capacity, it means, which I discussed with you, that you should be major. And being as a major, it is under your possibility of performance. I cannot accept anything which is impossible to perform by you, even if you are a major, even if you are a sound mind. Fine. Or if you are and even if you are permitted by a law. Now the next is not expressly declared to be void. Any of contract should not be declared to be as a void. I mean, you should fulfill all the formalities, and similarly when you start any kind of a contract, later on definitely it would be ended up, it means it should be executed by both the party. If any moment it should not be executed by any of party, or there is any kind of a problem occur, then the contract declared to be a void. And the last is the compliance with the legal formality. Definitely every kind of contract or the agreement required the legal formality, where we are talking about the documentations, the stamps, the signatures by both the parties. So it is very important. So whenever we are talking about the contract, or importantly the valid contract, both the parties should fulfill all these important essential elements. So once you are fulfilling all the essential elements, then only your contract can be completed, or your contract said by yes. It is the valid contract under 1872. Thank you so much.